Thanks so much, Mary Kate. Hello, everyone. Good afternoon or good morning, depending on where you're joining us from. Thank you for joining us for ASISTA's OVW webinar on labor-based deferred action and the impact on immigrant survivors. For those of you who don't know me, my name is Kelly Head, and I'm a staff attorney at ASISTA. I'm lucky to be joined today by two experts for today's webinar, Lynn Damiano Pearson, consulting attorney at the National Immigration Law Center, and Amy Chin Arroyo, legal fellow at Justice at Work, Pennsylvania. ASISTA's legal and policy director, Cristina Velez, is also on hand to help answer your questions. A few housekeeping matters before we start. Today's webinar is being recorded, and the recording will be sent to all attendees in the days after the webinar. The materials index was emailed to attendees last Friday, and the slides were emailed yesterday. This webinar has been approved for 2 CLE credit hours in Texas. If you are admitted in Texas, we will submit your CLE credits on your behalf. If you are admitted elsewhere, or if you're a Department of Justice accredited representative, please email ASISTA's program associate, Maria Lazzarino, at manager@asistahelp.org to request a certificate of attendance. Again, that email address is manager@asistahelp.org. Maria is on vacation until June 16th, but she will issue certificates of attendance when she returns. We do ask that you please ensure that your first and last name are included in Zoom if you're seeking CLE credit for today's webinar. We have set aside time at the end of today's presentation for questions, but you may ask your questions throughout the presentation. If we do not get to your question today, please review the second to last slide, which includes information on getting in touch with ASISTA for technical assistance. As Mary Kate said, we do ask that you please put all of your questions in the Q&A box where it is much easier for us to see and respond to them. Please feel free to use the chat to interact with each other throughout the webinar. And finally, I would like to take a moment to thank the U.S. Department of Justice Office on Violence Against Women for their support of ASISTA's training and technical assistance work. Without OVW support, today's webinar would not be possible. And let's get started. Next slide, please. So again, this is the list of the presenters. Next slide. Thank you. So we have a few learning objectives for today's webinar. By participating in the webinar, you will be better able to, number one, understand who qualifies for labor-based deferred action. Number two, understand the application process for this form of relief. Number three, to identify the intersections between labor-based deferred action and survivor-based immigration relief. And finally, to implement best practices around the representation of immigrant survivors of gender-based violence in the workplace. Next slide, please. So we're going to start with a brief overview of intersections between labor-based deferred action and survivor-based relief. Then Lynn will give us an introduction to labor-based deferred action. We'll then hear from Amy about a case study on the representation of immigrant survivors of sexual assault in the workplace. Lynn will discuss the nuts and bolts of the application process. We'll do some hypotheticals and discuss best practices, and then we will pivot to questions and answers. Next slide, please. So before I hand it over to Lynn, I just wanted to take a brief moment to talk about some of the intersections between labor-based deferred action and survivor-based immigration relief. Survivors are everywhere. In a group of immigrant workers who have experienced labor violations, you will almost certainly find immigrant survivors. And the converse is also true. Many of the immigrant survivors who you work with have probably experienced labor violations, which may have involved gender-based violence. Gender-based violence in the workplace, unfortunately, happens all too often in the U.S. As just one example, millions of women have reported experiencing unwanted sexual contact in the workplace. And when you think about the power imbalance that's inherent between employers and non-citizens who lack work authorization, that really heightens the risk of gender-based violence in the workplace. And workplace violence might make a survivor eligible for VAWA, U, or T relief, in addition to labor-based deferred action. Something to remember for your survivor-based immigration law practice are the intersections between domestic violence and labor exploitation. An abuser might force an immigrant survivor to work in a dangerous or an exploitative job as part of the abuse, and the survivor may then experience labor violations as a result of that coerced work situation. Or in some cases, the abuser might actually be the exploitative employer. If your client works for a business that's owned by the abuser, or if the abuser is the client's supervisor, pay particular attention to whether the abuser is committing workplace violations against the survivor. There are, of course, also more generalized intersections between gender-based violence and economic vulnerability. Immigrant survivors might experience financial abuse, including either being prohibited to work, forced transfer of their earnings to abusers, and the inability to save or access money. An immigrant survivor who leaves a relationship after experiencing that type of abuse may have little to no financial resources, which essentially leaves them in a position where they have little choice but to accept a job that places them at risk of experiencing a labor violation. And the lack of work authorization only compounds the abuse-related economic vulnerabilities that immigrant survivors experience. Confidentiality protections are also critical when you think about the intersections between survivor-based relief and labor-based deferred action. Many of you are probably familiar with the confidentiality protections that are found at 8 USC 1367. Those provide protections to non-citizens who are eligible for UT and VAWA-based immigration relief. Very briefly, they have two prongs. The first is that Department of Homeland Security, Justice, and State cannot make an adverse determination of whether someone is inadmissible or deportable based solely on information provided by a perpetrator or some members of the perpetrator's family. There's also an information sharing prohibition. Employees of those same agencies can't disclose information to outsiders about a non-citizen who is eligible for those forms of relief, with some limited exceptions. USCIS's safe address guidance, which is in your materials, clarifies that these protections should apply to survivors who are eligible for UT or VAWA relief who are also applying for labor-based deferred action. And includes some helpful information on how those protections, which we are most familiar with in the context of UTs and VAWAs, how they apply to immigrant survivors who have multiple forms of relief pending. The guidance makes it pretty clear that DHS can't disclose to an abuser, for example, any information that's found in a survivor's labor-based deferred action application if that survivor who's applying for labor-based deferred action is also eligible for UT or VAWA-based relief. So when you apply for this type of relief for a non-citizen who's protected by 1367, we encourage you to flag that in your cover letters and also to attach copies of the safe address guidance. And I will now turn it over to Lynn.
Next slide, please. Thank you so much for that introduction, Kelly, and for grounding us all in these intersections. Again, my name is Lynn Damiano Pearson, and just a little bit about my background. I am consulting now at NILC specifically on this new deferred action process, having worked on one of the very first cases where workers were able to access deferred action based on a labor dispute that actually occurred a couple years before the new guidance was issued in January of 2023. And prior to that, I was an attorney at Tahrir Justice Center doing gender-based and survivor-based immigration work. So these intersections are really important to me, and I'm so glad to be having this, being able to have these discussions with you all today. So I'm going to start with a really brief overview of just the new policy, very generally, and then Amy will kind of give this really compelling case example of how it plays out in real life and in a gender-based, survivor-based scenario. And then I'll come back and really unpack all this and get into the nuts and bolts of filing for this new form of immigration relief. Next slide, please. So this new policy, where did it come from? What are the sort of background? It's something we all sort of know inherently, and that is that people who are undocumented are exploited in the workplace based on their immigration status. And this has a chilling effect on labor agencies' ability to protect labor laws, not just for undocumented workers, but for all workers, because claims are not brought due to intimidation and fear of immigration-related retaliation by workers. And that is sort of the underlying policy that has driven this campaign to get this new policy in place, and has been ongoing really since the Obama administration, where there was an initial push for this process. And obviously that was stopped in its tracks during the Trump administration. And then sort of resurfaced during the Biden administration. As you may know, the Biden administration has been quite strong on labor issues, and that has been one of the reasons I think that this immigration benefit has come through, even though, as we all know, there's been a lot of disappointments in the immigration field as far as this administration's willingness to change existing policy. So specifically, workers are often afraid to report labor violations to any labor agencies for fear of retaliation by their employers. Again, this makes it impossible at times for labor agencies to even know about these violations, let alone enforce the laws that they have an enforcement interest in enforcing. And this dynamic perpetuates exploitation amongst all workers. So this means depressed wages, wage theft. This means unsafe working conditions and dangerous conditions. And this also can mean suppression of the ability to organize and form unions. And we'll talk a little bit more later about the various agencies that protect all of those labor rights. The one other thing that's really important to know here is, despite these fears and despite the terrible worksite raids we saw during the Trump administration, despite all the fear around coming forward, workers have been doing that. And a big part of why this policy was successful was worker organizing and workers coming forward despite fear of retaliation to demand fair wages, to report labor violations. And those came together into a number of campaigns through unions and other organizations that were able to show the need for non-citizen workers to be involved in these labor investigations and cases. And so they are a big part, the directly impacted folks are a big part of how this policy came about in the first place. Next slide, please. So what happened on January 13th, I believe, of 2023. So this was a big announcement at the AFL-CIO headquarters in DC. You may not recognize anyone in this photo except for Secretary Mayorkas, because for the most part, they are leaders in the labor movement, both from unions and some of the large nonprofits, AFL, United Farm Workers, someone from NILC was there, and also from some of the other unions and labor rights organizations. So just again, to reiterate that this policy really, in a way, came out of the labor rights movement, and in some ways has been less known and less publicized among the immigrant rights community. And that's another reason why I'm so glad we're here talking about this today, because it's really important for these two worlds to intersect. This is a policy that only works when there is both action by a labor agency and action on the part of DHS. So it's really essential that we start thinking more collaboratively about these two areas of law that really often involve the very same people, the very same survivors, the very same non-citizens who are facing these labor abuses. So this new process, it basically was very explicit that it wasn't anything new. Deferred action is already an available type of immigration relief, and that it was just clarifying, enhancing, and streamlining the process for immigrant workers. And basically, it just popped up on the DHS website and provided these instructions, both for the labor agencies to request, basically send a letter request. It's now called a statement of interest from a labor agency to DHS that requests prosecutorial discretion, typically in the form of deferred action, though some letters have also referenced parole. for those workers to be protected during the course of a labor dispute or investigation. The letters typically cover workers at a certain work site for 24 months. And within that 24 months, they can apply and get a deferred action grant that actually runs 2 years from that time. So it does provide a decent sized window of time. The DHS website has an FAQ where it actually lays out the specific filing requirements that we'll talk about more and in more detail later on. And it provides for this centralized process in Montclair, California, a specific office sort of lockbox that's only accepting these applications of deferred action and work authorization, specifically based on a labor dispute where there's one of these support letters or statements of interest from the labor agency. This was a big victory because for the handful of sort of test cases that were filed pre-announcement, the cases were being filed at the local field offices with a lot more inconsistent results and delays. So the central office so far has been processing cases much more consistently and much more quickly. Next slide, please. So very broadly speaking, what are the benefits of this new process? 2 years of deferred action and work authorization. You can request a social security number through the work authorization application, access to apply for state IDs and driver's license. That actually varies a little bit state by state. There are some states that do not include this particular subcategory of work authorization for driver's licenses. Georgia, where I'm from, unfortunately, is one of them. And tolling of unlawful presence for 2 years. So there's no accrual of unlawful presence while the worker has this protection. So broadly speaking, those are the benefits. Obviously, it's temporary. And we'll talk a little bit at the end about sort of renewals and what we know so far about that possibility going forward. But a big thing I want to emphasize, and I will continue to emphasize, is that even with the temporary nature of this type of relief, because it is being processed so quickly, at least for now, it can really be something to look at as a tool with someone who may have eligibility as a survivor for another type of relief that may be just much further off in the future as far as processing time. This can be a path to an EAD on a much shorter time frame. Next slide, please. Oh, and I think actually now I turn it over to Amy and she will talk about her case, and I'll see you all in a little bit.
Sorry, I think I was muted. Can you all hear me now? Oh, great. Okay. I think I saw a question in the chat about how quickly it can be processed. I don't know off the top of my head, but it's a matter of months. I think less than 6 months at this point, probably faster. So my name is Amy Chin-Arroyo, and I work at Justice at Work in Pennsylvania, and I will be presenting a case study about how immigrant sexual assault survivors can benefit from labor-based. Oh, awesome. Thank you, Lynn. Seen cases approved in under 2 months. Thank you. So I'll be presenting a case study about how immigrant sexual assault survivors can benefit from labor-based deferred action. Before I do that, I'm just going to provide a little bit of context about Justice at Work, or JAW, what we do. So we're a nonprofit legal aid Oregon PA. Our goal is to support low-wage workers as they defend themselves against mistreatment in the workplace. The majority of our clients are undocumented immigrants. So because of that, we do work primarily at the intersection of immigration and employment law. A lot of the legal issues that our clients encounter include things Lynn has already listed, such as wage theft, sexual harassment and assault, discrimination, retaliation, and labor and sex trafficking. So we have had success obtaining statements of interest from labor agencies for labor-based deferred action. And we've also successfully applied for labor-based deferred action for some of our undocumented immigrant clients. Before I go into the case study, I'm just gonna say a quick note on confidentiality. The clients I'll be talking about today live in a rural area with a lot of anti-immigrant sentiment. They are also dealing with, as I'm sure all of you are familiar with, they've dealt with shame and stigma and victim blaming because they are survivors of sexual assault. In spite of that, they still do want to share their story to help others, but they also have a strong desire to remain anonymous. So because of that, I won't be sharing names, specific places, or factual details when talking about this case study. Next slide, please. Okay, so this slide basically provides a roadmap of the process we went through with our clients. So I'll start with the initial screening. We received a warm referral from a partner community organization, and this organization basically told us that they were in contact with Latina immigrant women who had experienced sexual assaults at a food processing facility in a rural area of the state. And just for some context, this particular food processing facility is a major employer of Latin American immigrants in the area where it's located. For the past several years, JAW has actually received calls and heard about multiple instances of sexual assaults perpetrated by male supervisors against Latino workers at this particular facility. The vast majority of the sexual assault survivors working there never reported what happened to them because of fears of retaliation, firing, and deportation. And the few who did report faced severe retaliation as a result. So the fears were not unfounded. So after we heard from this community org, we were able to meet with our clients, and it's actually not on here, but I would say step one was actually just getting them set up with therapy because they were so traumatized by the ongoing sexual assault and harassment that they were experiencing. This might not work with all clients, but I think in this case, it was important for us to establish a baseline level of psychological safety and support, because without that, I don't think our clients would have been able to really understand and undergo the lengthy and at times re-traumatizing process of pursuing various legal remedies available to them. So step one was actually, after the initial screening, getting them set up with therapy, which was kind of hard because they're in a rural area. Therapy is hard to access to begin with. And so we actually ended up partnering with a nonprofit mental health services provider called La Puerta Abierta, and they do Spanish teletherapy. So that really helps sort of stabilize our clients and get them to a place where we could talk about next steps in terms of legal options. So for issue spotting, we realized that they would qualify for U visas and had also experienced sex-based discrimination. So we helped them make a report with the local police department and also file charges with the EEOC, which is the Equal Employment Opportunity Commission. And they're, as many of you know, a federal agency, and they handle discrimination complaints, cases of discrimination on the job based on protected classes such as age, sex, religion, national origin, race, color. And something that's important especially for our clients, was the ability to file anonymous third-party charges because our clients were so terrified, frankly, and rightly so, given the past history at this workplace of what could happen. We let them know that an option was for Justice at Work to submit a complaint on their behalf as a third party and not list their names at all so that they could remain anonymous. So that's what we ended up doing. And they had an interview with an investigator, and we also submitted a request for U visa certification to the EEOC. And so at this point, we're around 2022. Our clients are still, especially one was basically working at the place where she was raped, and so being re-traumatized on a daily basis because of that. And so, as a lot of you know, the U visa is not a fast process. So we were trying to think, like, what can we do to see what other options are available. And so at the time, my colleague at JAW, Lorraine Crone, had been in contact with labor rights advocates from other parts of the country. And we had heard that there were test cases that were successfully labor-based deferred action cases that were successfully being filed. And so what that was basically labor rights advocates in different parts of the country had been asking different labor agencies to issue a letter to DHS recommending a grant of deferred action and work permits for a subset of the workforce at particular workplaces that were being investigated. And so in talking with Lorraine, we felt like this would be a great test case, because here we had a workforce that was primarily immigrant, many of whom were undocumented, and nearly all of whom were afraid to report sexual assault, harassment, other labor rights violations because of the very real fears they had about retaliation, being fired, possibly being deported. So we submitted, this was before the January 2023 policy came out with DHS. So we're sort of like testing the waters. We're like, we'll try this out with the EEOC. The worst that can happen is they'll say no, but just to give it a shot. So we submitted that request for a statement of interest in the summer of 2022. Shortly thereafter, we actually received the supplement Bs, or the sub Bs for the U visa certification. So I think in a way that sort of helped move the U visa process along. Like it, so we got that. We filed the U visa applications for our clients. In the course of doing that, we realized that one client in particular was also eligible for a T visa based on the facts in her particular situation. So we are currently preparing that application as well. And then earlier this year, shortly after DHS issued guidance about their streamlined policy for labor-based deferred action, we received a statement of interest from the EEOC, which is great because we are now able to apply for deferred action for our clients, and they'll be able to get a work permit as a result. And one thing that was really great, which we hadn't anticipated, is just how broad and generous this statement of interest is that we received, because this particular facility had such a long history of widespread sexual assault and harassment. The EEOC basically stated that workers who had been at this particular facility at any point working there, going several years back to the present, are eligible for, they recommend that they be granted deferred action and employment authorization. And so this potentially covers hundreds of workers, immigrant workers who are had worked at this facility, and currently some who are still working there right now. So next slide, please. Okay, so I just sort of gave a brief overview of the timeline and sort of the process we went through. And looking at that, it seems like, wow, we were able to basically go for every possible form of relief available. However, the process itself was not as straightforward or easy. And that is because, as many of you, probably all of you know, there are so many barriers that immigrants with precarious immigration status face. So our clients, on top of facing what sexual assault survivors deal with, shame, victim blaming, stigma, they were also dealing with every single one of the factors listed on this slide. They were afraid of being deported. They were afraid of law enforcement. They had been threatened by their employer. They were in a hostile community. They faced language and cultural barriers. And there was also a general fear of the government and judicial processes. And so for a lot of the workers, immigrant workers at this particular work site, this combination of very daunting barriers was enough to deter them from ever reporting, and understandably so. So the fact that our clients still wanted to report and pursue an investigation, file charges, that I think was quite remarkable. And a little bit later, I'll go through some of the reasons why that was able to happen. Next slide, please. And so the previous slide had this laundry list of daunting barriers that undocumented immigrants face when trying to access services and justice. And what is so powerful about labor-based deferred action is that this policy directly undercuts and greatly diminishes a lot of the barriers. I would say every single one of the barriers that were listed on the previous slide. So deferred action alleviates deportation fears because quite literally a grant of deferred action states that you can be present in the country without fear of being deported for this time period of 2 years. And this will be renewed during the pendency of the investigation and litigation. And yes, there can be some uncertainty about how long will that investigation take? What if the case settles? What if there's a resolution? But oftentimes cases can take a while. So it does eliminate that very real fear of deportation. It promotes cooperation with law enforcement. And it also diminishes the chilling effect of employer retaliation by taking the teeth out of the employer's threats. So if an employer says, don't talk to the investigator, don't even think about reporting because I will call ICE on you and you will be deported. Well, once there's a deferred action grant, that threat is basically an empty threat. If an employer says, if you talk about this, I will fire you, that can happen. But with the work permit that comes with the deferred action, that fired employee will have more options for pursuing alternate employment. And that will also, the fact that they can pursue alternate employment, that they have the grant of deferred action, will make it more likely that they'll report the retaliation and share that with the investigators, which only further aids the investigation and furthers the goals of labor agencies to protect the rights of workers. It also diminishes the chilling effect of community hostility. And I think this was quite apparent to us at JAW and working with these particular clients, because where they live and work is a rural area with a lot of anti-immigrant sentiment. And it's quite clear to them that while their labor is wanted, their presence is often not welcome in the community. So the fact that a federal agency is saying, you know what, that might be the case, but we want justice for you, your rights matter, we are going to investigate what happened to you, and to make that happen, we will do our best to take away the barriers that are preventing you from talking to us as much as possible. And I think that is really such a game changer, because our clients had heard and seen for so many years, they'd gotten the message that basically they don't matter, what happens to them didn't matter, that they could just be exploited with impunity. So I really think this is such a powerful tool, and I'm so glad, as Lynn and Kelly have said, that we're able to share this with so many immigration practitioners at this training. And so going on to the next bullet point, this builds trust in governmental and judicial processes. That's a great question, Sandra. I'm not sure. I might defer to others to answer, because I've never actually gotten that far in the process, or with these particular clients. So, but thank you for that question. Yes, so, and it also enables immigrant workers to access justice and services, which is what we're seeing with our clients right now. Next slide, please. Okay, this is my final slide. I'm just going to go over some lessons and considerations that have applied to our clients, and will probably apply to people you all work with and will work with in the future. So I kind of alluded to this at the beginning. I think here at JAW, we really firmly believe that holistic trauma-informed services are absolutely fundamental at every step of the process, from the initial consult to interviewing to counseling, and to building partnerships with other organizations and people who can provide services and expertise that we don't have, because we're a small organization and we specialize in certain things, but we can't be an expert or have the capacity to be all things to all people. And so an example of that, which I talked about earlier, is therapy. Again, not all of our clients will be open to therapy or want it, and it might not work for everyone. But in this case, I do think it really set the stage for us being able to pursue the legal remedies that we have. So thank you, Cristina. I like that comment. So yes, so being trauma informed, I think not only includes like attending to mental health needs, like survival needs, food, housing, because I think if basic needs aren't met, like we can't really adequately begin to address what can be done legally for a client. And I think it also extends to language access. So since a lot of our clients are Spanish speakers, most of our staff is fluent in Spanish. And when in situations such as law enforcement interviews, where I think it's important to ensure that adequate or competent interpretation is available and has been set up beforehand. And sometimes that can require some tricky or uncomfortable advocacy in the moment. For example, for a couple of our clients, we quickly realized during the law enforcement interview that the interpreter provided was not completely or accurately interpreting everything. So we put a pause quite early and informed the investigator, and then brought in one of our staff to interpret. And I think that's just so important, because at a very basic level, we want to make sure the information conveyed is accurate, it's complete, and that our clients are being heard. And I think it's also important to, if possible, accommodate a client's request for them to feel safe. And I'll give an example. One client did not want a male interpreter, so we did our best to provide an interpreter who was a woman. We were able to do that the first interview because I stepped in, but the second interview we were not able to, but we had her meet the interpreter beforehand. So she felt comfortable and sort of did some preparation around that. So it wasn't like we were springing this on her. I think also going into trauma-informed services is, while deferred action is a great option if it's available for a lot of clients, for some clients, it might not be the most trauma-informed option, because sometimes, like if there's an active investigation, some clients might not want to participate in an active investigation so if that is the case, that unless the statement of interest has already been issued, and that might not apply, but in some cases a client might not be willing to speak with law enforcement or feel quite uncomfortable. So that can happen. Just something to keep in mind, though. And then I guess for our clients, protecting clients' identity in the workplace was of paramount importance for reasons I already went through. And so the EEOC helped with that, in that we were able to file an anonymous third-party complaint. And then also in their statement of interest, the EEOC has a policy of not putting the names of the complainants in that statement of interest. So that was very helpful as well. For issue spotting, and I believe Lynn will go more in depth about this soon. So for immigration practitioners, we're often thinking, is there a U here? Is there a T here? Is there a VAWA case? Adding to that, for labor-based deferred action, we can consider, is there a crime that occurred at a workplace, and can it be reported to a labor agency? So if your client or potential client has experienced wage theft or worker misclassification, such as a full-time employee being misclassified as an independent contractor, that can be reported to the Department of Labor. Health and safety violations can be reported to OSHA. Discrimination can be reported to the EEOC, and protected concerted activity, which people often think of as unions, but it also includes basically just workers coming together to complain or to try to advocate to make their work conditions better. Complaints about that can go to the NLRB. And if possible, we think that the NLRB has actually been quite quick in turning around issuing statements of interest. So if there is, if that issue is spotted, it would be great to request that from the NLRB. Lynn does have a slide listing all these agencies, so don't feel like you had to write them all down. Because also, I guess for issue spotting, it's okay if you don't spot everything all at once. And we aren't experts in all things, so we encourage partnering with other orgs or other practitioners who have more expertise to sort of talk through the issues. So maybe other workers' centers or nonprofits that specialize in employment law in your area, other colleagues. Even for this case study, we didn't spot all the issues all at once. We spotted the U visa first. Then when that was sort of pending the request for the supplement B, we spotted, or Lorraine spotted, the possibility of applying for labor-based deferred action. So that came about some months later. And then when I was basically having my U visa applications reviewed by a supervisor, she came to me and said, you know what, Amy, this particular client also could qualify for a T visa. So we did some research to confirm that, and that turned out, so we're pursuing that as well. So it really is okay if you don't spot everything all at once. We didn't here at JAW, but I think that's very normal, and I think it's just important to sort of keep options open, keep various options on the horizon, and talk to people who have more experience, more expertise, And I think a lot of people are happy to discuss. Like, we've consulted with Lynn. She's given us a lot of great advice. Yeah, so then my final bullet point, this we're sort of still grappling with, the question of how to identify and support other eligible workers while also maintaining confidentiality. So once you get a statement of interest, depending on how broad it is, it could potentially cover lots of people. Like in our case, it's potentially covers hundreds. So an immediate question that comes to mind is, how do we get the word out? Second question is, how do we build capacity to help all these people apply? And then if confidentiality is an issue, like in this particular case, we are currently grappling with, how do we identify and support eligible workers while also protecting our current clients' confidentiality? So because this process, the streamlined process, is relatively new, we wanted to ensure that our clients knew as much as possible going forward, the pros and cons, so that they can make an informed decision. So we had the statement of interest translated into Spanish. We had the clients read it, we discussed it at length with them, went over the pros and cons of pursuing deferred action, of not pursuing it, of sharing it with other workers, of potentially how to share it with other workers. And we really wanted them to know that the decision of how to go forward was up to them. So for one particular worker, there was a lot of concern about negative potential ramifications of publicity, basically being afraid of being outed as one of the complainants. And so we basically did not want to pressure her. So we were like, take your time, talk it over. We're happy to discuss any concerns you have. So she ultimately decided she was okay with sharing the letter because she does want others to benefit. However, we are starting small, and we're starting small both because of confidentiality concerns as well as limited capacity issues. So we're going to start with applying for our current clients. And we've also asked our clients to identify folks they think will probably be able to benefit, that they feel comfortable talking to about this process. We're not posting the statement of interest on a website. We're not actively publicizing at the moment. However, our approach is tailored to our clients' particular needs. Other advocates around the country have approached things differently. Other advocates have held legal clinics to get the word out and to identify eligible folks, and have also given presentations to the community to get the word out as well. So these are just some of the lessons we've learned and that we're still learning. I think that's it for me. So I will turn it back over to Lynn and Kelly. Thank you.
Thank you so much, Amy. That was such a powerful example of how this process can help survivors and workers, and how these sexual violence often plays out in the workplace. Next slide, please. And honestly, Amy also kind of previewed a bit of what's coming next. So I'm going to talk about statements of interest, but I'm also going to rely a little bit on what you heard already. Next slide, please. This statement of interest process, as you'll see, is on the timeline, is a requirement, is a prerequisite to getting to the DHS and USCIS process. So steps 1 and 2 are with the labor agency. Steps 3 to 5 are with USCIS, and then the kind of nebulous unknown renewal process we believe is going to require action by both agencies, some kind of re-upping from the labor agency that they are still in need of protection for these workers, that there's still an investigative or other governmental interest in protecting these workers while the case is ongoing, and also a renewal grant from DHS. Next slide, please. And so these are the labor agencies involved. You just heard quite a bit about the EEOC from Amy. And so she, as she explained, it handles all the kind of discrimination cases of protected groups in the workplace. She also briefly mentioned some of the other key agencies. The Department of Labor is split into two parts: the Wage and Hour Division that covers wage theft. It also investigates and protects rights of H-2A and A and B workers. And the OSHA is the Safety and Health, Occupational Safety and Health Administration. So both of them have been involved in this process so far. And the OSHA specifically is where complaints would go that involve some kind of danger in the workplace or unsafe condition of any kind of toxic issue or injuries, all kinds of things like that would go to OSHA. And then the NLRB, as Amy mentioned, can investigate any kind of labor violation if it involves some kind of concerted activity. So that means that wage and hour issues, wage theft issues, safety issues, if any group of workers, even two, have come together to raise those issues and have faced retaliation because of it, they may be able to file a charge with the NLRB. And very briefly, just to add that since this process has started, the NLRB has been the fastest and most receptive to these issuing these statements of interest. So we've had a lot of successes there so far, and they've been much faster than the Department of Labor. The last thing that was a big win when this policy came out is that it included state and local agencies. So a number of states in this country have better labor laws, stronger labor protections within the state. And so their state counterpart to OSHA, to the Wage and Hour Division, to the EEOC may be a better forum for the worker. And those agencies are slowly but surely developing their own policies around these requests for a statement of interest. But California is kind of leading it. They already have their own public-facing FAQ on how to request a statement of interest. But we've seen a lot of interest and activity and advocacy at the state level in a number of other states already. One thing that I saw in the questions I want to address very quickly is that all of these agencies have their own state statutes of limitations. So that is one thing that you will want to consider, is if you're screening a client and they report a labor violation, it will depend on the agency and the type, and sometimes even the type of case, but they all have statutes of limitations that typically run, I'm trying to think if there are any that run more than a year. But for the most part, there's a smallish window where that labor violation will have had to occur. So if a client reports something that happened at work many years ago, this will not be a process that they can use, most likely, because if they report it, it will be outside of the time that the labor agency is able to investigate. Next slide, please. So here is what a statement of interest looks like. And again, it's just a letter. It's a letter from the labor agency to the director of USCIS, and it requests prosecutorial discretion. Sometimes it says in the form of deferred action, sometimes it says deferred action and parole in place, sometimes it says deferred action and parole. And it's specific to a workplace and a period of time. So sometimes it usually will cover all workers during a time frame where they believe this labor violation occurred. So it can be current and former employees during a specific time frame. And what Amy mentioned with respect to her EEOC letter, that is actually across the board. All of these letters cover all workers at a given work site for a given period of time. The idea behind that is that all of them may have relevant information to an investigation, and there isn't a need at this point to identify specific witnesses and victims because there may be others that come forward. And so all of these letters cover an entire workplace, and that can create a very large number of eligibility if the work site employs primarily undocumented workers. So all of the letters will contain those kind of key things: the time frame, the location and name of the company, and and the governmental interest in prosecutorial discretion. So often they'll lay out some facts that show why there's fear of retaliation, why if there's been actual retaliation, or just kind of a generalized chilling effect of that this employer has created that would make workers fear coming forward, but for this protection. Next slide, please. So this slide is a little bit duplicative of what I just said as far as what is required to, but a little bit more about what's required to request one. So there has to be some kind of labor agency case pending, or in some cases, closed cases will be considered. I saw a question about that as well with the EEOC specifically, but in general, the EEOC specifically referenced closed cases on their FAQ on the website, and other agencies have also suggested that they will entertain those types of requests. It really depends on if there's an ongoing governmental interest. So if the case is in some kind of settlement or monitoring period where there's still an ongoing interest in ensuring this employer is complying with labor law, there is an argument there that there could still be a statement of interest issued, and it may be fact specific to whether there's ongoing fears of immigration retaliation. As far as the scope of the letter, I covered that. They are worksite wide. Who can request them? So anyone can request one of these letters. It's an online form now. Each agency, for DOL, it's an online form. I believe there's an email now for NLRB, EEOC. I'm not sure if there's a specific email, but there's a specific procedure laid out online to follow. But in general, the people who do file these and should file these are ideally experts with labor law, labor organizers, and or labor and employment attorneys who can kind of articulate best the labor violation and kind of put forth the strongest labor complaint. So in general, if you're an immigration attorney and you find out about one of these labor violations, the best thing to do, if possible, is find labor attorneys or organizers at a worker center in your community, make those connections and get assistance from them in the next steps as far as how best to advocate for your client through this process. That's not always possible. And again, it is possible for other types of attorneys and non-attorneys. This process is supposed to be accessible pro se. In fact, DOL has translated its instructions into about a dozen languages. So they can be done pro se, but ideally in terms of putting forth the strongest labor complaint or charge, it's best to work with someone who has familiarity filing specifically before that labor agency. So I think that's it for this slide. Next slide, please. So the key elements, again, I think this was kind of laid out already, but this is for the request, what you would input in your request versus what will then be laid out in the letter. You would want to include the name and address, the case information, assuming there's already been a case filed, which normally there has been. You would want to summarize those facts. You would want to make those arguments about what the government interest is in protecting the workers at this work site, and then include any specific threats or actual retaliation that has already occurred, at least to one worker. And then the contact information for the requester. That part is important because, as you saw, that letter is addressed to USCIS. So in order for the advocate or the worker to get a copy of that letter, you have to provide the information for the labor agency to send them as well, so that they know when it's been issued and they can be sure to be applying on behalf of the worker who may be initially filed the complaint and other workers who may come forward, who may be covered by this letter and working at the same work site. One thing that's really, really important not to include is personal identifying information and even names of specific workers. The labor agencies have specifically asked not to have that information included. They have concerns about discoverability of people's immigration status. There's some concerns about what type of labor relief they'll be entitled to, because there's some bad case law on undocumented folks having less options as far as remedies. for labor violations, all of which makes it very important. So I know this is kind of counterintuitive. You may be like, if you're representing one person who's involved in this labor dispute and maybe even filed the specific labor complaint, to not name that worker, but you can do it. You can say a worker or workers at this site, and you can talk about them and reference the case, but not the names or any personal identifying information of the individual workers. Next slide, please. Okay, so that was so that kind of concludes the portion on the labor part of this process. And again, just to emphasize, that statement of interest is the critical piece that you must have in hand before you can move on to this next step, which is applying for deferred action. This whole new setup that was issued in January by DHS is predicated on anyone applying having one of those letters and the worker falling within the scope of the people and place covered by that letter. So I'm going to start by talking about screening and advising, because although as immigration attorneys, I know many or all of you screen clients all the time for different forms of immigration relief, and this may seem a little bit obvious, but there are some special considerations about screening and advising for this particular benefit that are worth discussing. Next slide, please. So risks and considerations in applying. So the first one is that DHS will show deference to the labor agency's enforcement interest, but will exercise its own discretion in terms of balancing equities. So what does that mean? Basically what it means is there are literally no specific bars, there are no grounds of inadmissibility, removability. There are none of those specific kind of red flags that we look for in immigration cases that apply to this deferred action process. It is simply a balancing test of positive and negative equities in order for the USCIS adjudicator to render a decision on prosecutorial discretion. So within their discretion, we think the biggest positive equity, and what should be kind of the main one, is that they are involved in this labor dispute and that the labor agency has this governmental interest in investigating this case and enforcing labor law. However, if there are additional negative equities in particular cases, and this is generally, as you know, immigration and criminal history, though we've seen successes and approvals even with some of those, so we'll talk more about that. But if there are more negative equities, that could offset the balance and result in a denial. So that's something to consider when screening an individual client, and also to consider whether there's a way to balance those equities, again, by including more positive equities. So, not just the governmental interest, but maybe also some community, showing that your client is pillar of their community, and other kinds of positive equities that we typically would submit in other types of immigration applications. The other issue is we can't guarantee what's going to happen to the information in the application in a future proceeding or action. That's partly because we can't see the future, and we don't know what future administration may do with these applications that are either denied or simply that the status has expired after 2 years. Currently, we are under the 2011 USCIS NTA memo, which only requires referral to ICE for very specific criminal convictions. That is not typically an issue unless your client has a very serious criminal conviction. And so then we're just kind of in this gray area of what will happen with a future administration. Lastly, and this is part of the new process that was rolled out in January, is that there's kind of this jurisdictional distinction between cases with prior removal orders or with current UIR proceedings and cases without them. USCIS adjudicators will adjudicate the ones with no prior immigration history, but the others will be forwarded to ICE, and we've been specifically told will be forwarded to ICE's HSI parole unit adjudicators, who are supposed to have been trained on this process and not looking at them in any way for enforcement, but simply to adjudicate them on the same kind of criteria that USCIS would. Still, that's obviously a concern for clients to have their cases forwarded to ICE. But we are still also covered by the victim-centered approach directive. And our hope is that these adjudicators would be looking at these applications through that lens. Next slide, please. Screening workers for prior immigration history. So as I mentioned, this is a big distinction in this particular process because it will decide who is adjudicating these decisions. You may be required FOIA-ing. The fastest turnarounds we're seeing are filing online for USCIS to get the A file. They're supposed to respond in under 30 days, and then FBI background checks, which often have border arrests included, are coming back within a couple of weeks by mail or a few days if sent electronically. Other immigration history to keep an eye out for: turnbacks at the border, expedited removal proceedings, and executed orders where someone has departed and returned. All of those, is our understanding, will be forwarded to ICE. So those are important factors to consider. The last one is not jurisdictional, but just denials of affirmative applications. So if someone has a prior history of filing with USCIS and those denials are for certain negative equities, like any kind of fraud or misrep or criminal history, that could certainly weigh into the adjudicator's decision in these cases as well. Next slide, please. Screening for criminal history. So as I mentioned, there's only these egregious public safety and national security convictions outlined in the 2011 NTA memo that would dictate automatic referral to ICE. All other crimes are going to just go to this balancing test to that adjudicator's discretion. So we've seen minor convictions get approved without a problem. I think the most serious I've heard of is a DUI conviction. There are no, substantial misdemeanors that are disqualifying the way there are for DACA. And so we just advise to get the records, see what's there, plan to file just the criminal dispositions of any cases with criminal history, and look out for some things we know or tend to be more problematic before USCIS: multiple convictions beyond traffic violations, recent convictions, and convictions involving DV, violence, and drugs. Next slide, please. Screening for other labor-based immigration relief. So as Amy illustrated so well, the same workers who may be eligible for this labor-based deferred action may well be eligible for something else that sort of flows through this process, even if it's not directly related to the deferred action itself. So the first one I want to flag, and I think it's really an important one to consider, is OPLA PD. We have seen a lot of success with dismissal, admin closure, and other and termination based on a worker being involved in one of these cases, and not just that they've received deferred action, but even just at the point that they are covered by a statement of interest and are eligible for a form of relief before USCIS. So for clients who have removal proceedings, this can be really valuable and may sort of overcome the concerns about ICE being the adjudicator of that application. Second, parole in place. This one is really nebulous. We haven't really seen, it's kind of untested at this point, but both a number of the statement of interest letters that we've seen from the labor agencies, as well as the DHS guidance on the website, reference parole in place a couple of times and suggest that there is the possibility that this would be accessible to some workers covered by these letters. Obviously, this can be a huge benefit to individuals who have qualifying relatives who they can adjust status through, or for Cuban nationals who are covered by the Cuban Adjustment Act. So that's definitely something to look out for and consider advocacy around. The U visa, obviously, I think many or all of you here know plenty about U visas, but as Amy described, that the same underlying abuse in the workplace that occurred for requesting and receiving the statement of interest to apply for deferred action can also rise to a qualifying crime for a U visa. And then for T visas, similarly, the underlying labor abuse, if it involved forced fraud or coercion, can rise to T visa eligibility. Next slide, please. So this slide really just unpacks what I talked about on the previous slide. I'm going to just make a few key points in the interest of time. I think one important thing with the Opal PD is that if you have a survivor who has a pending URT, that this can, but also has a prior order, this can be a faster route to terminating and dismissing and getting those removal proceedings to go away. With parole in place, one thing that's important to flag is even though this is referenced in this process, it is not part of the new Montclair filing process. They will not accept parole in place. They will only accept deferred action and work authorization requests. UNTV says that the key thing there to note is that labor agencies will certify, like in Navy's case, it's certified by the EEOC, the DOL, both wage and hour, and now OSHA and the NLRB will also certify labor-based crimes that are related to the labor dispute. And there's specifics among each agency. Some will cover any related crime. Some have a specific list I think Kelly will talk about. And just again, with respect to the TV says this can just, the benefit there is the shorter processing time and that you do not need a certification, but otherwise has the same benefits as the U. Next slide, please. And so this is a chart that's a little bit, it's got a lot of information on it, and I think you'll be receiving these slides, and it might be better to look through it separately in the interest of time. But basically, this is showing some of the different, just comparing the different protections that can flow from labor-based relief and survivor relief, and sort of where they all fit together and what the benefit can be. And the big picture takeaway is that this deferred action process can be kind of a placeholder while these other types of benefits are processing. Next slide, please. Okay, so I'm going to really quickly go through filing the application. I want to make sure that Kelly has enough time to really dive into the survivor-based intersections here. Next slide, please. So very quickly going through the required forms, we have the G325A, that's a one-pager. It's just biographical information. The only kind of issue to consider is it does request other names used. So workers who work under a different name will need to disclose that, but the I-765 does as well. So it's just kind of not something that is not, is unavoidable. However, for those who are covered by 1367, they will still have those same confidentiality protections that they have with other forms of relief. And next, there's the I-765 worksheet, which is also a one-pager and just requires some showing of economic need to work, but without any supporting documentation. It's a pretty easy one. The I-912, which I'm sure many of you are familiar with, this is for the fee waiver. If the client is unable to pay the $410 filing fee required for the I-765, it's a bit more onerous and requires supporting documentation. And so far, we've only seen success when the client is eligible for a means tested benefit, but we have very little data to go on so far from this new process. And then of course a G28 if they are represented by counsel. Next slide, please. So here are the other documents that are required or highly recommended. Statement of interest from the labor agency, as I've mentioned many times, absolutely required. This is the #1 thing that is needed for these workers to be eligible to apply. Cover letter, not amongst the requirements, but obviously a very important piece to include to make those arguments of why this individual is both covered by the letter and that the governmental interests articulated in the statement of interest apply and should warrant the discretion of the USCIS or ICE adjudicator. The other stuff is pretty straightforward: proof of identity, entry documents if they exist, a signed statement from the applicant. This can be really brief, and then proof of employment. This has been tricky for some folks who have informal employment, but we believe there's different options for how you can prove it, and we're I think this is something that people have tried. I don't know if it's been officially successful yet, is even just using a declaration from the client to state their employment if they don't have any formal employment records. The other thing we've seen is using some communication with the labor agency to show that they have been involved in this particular labor case and therefore would be covered by this letter. Next slide, please. The signed statement requirement. So this can be really simple. We've seen things as simple as option 1, an attestation that basically says I'm involved in this case and I authorize my attorney to represent me in it, and I'm asking for deferred action and really nothing further. And then there's a short statement or declaration that just affirms that they worked at this work site during the scope of the statement of interest, that if they fear or had any actual retaliation occur to them. And we suggest that if there is some kind of negative history, criminal history, or significant immigration negative history, that you would maybe address that in the statement and provide some mitigating factors around it. And then the third option that that has been successful is the worker just co-signing the cover letter with a certificate of translation as needed. Next slide, please. This is all optional positive equity evidence that we don't think should be necessary really unless there's a need to overcome negative equities. The one thing that we've been kind of submitting out of hand because it's very easy and always a good equity is US citizen family members, just providing those birth certificates and passports to show those community ties very easily. And then these are some other suggestions. And as I mentioned, I think on the criminal history side to include the criminal disposition and potentially some other positive factors. Next slide, please. I think this is the last one for my part here. Renewals. Now, this is just the process. This is literally a quote from the DHS website. What it says is basically that if there's an ongoing interest on a case-by-case basis, there may be eligibility for subsequent requests. They don't even call them renewals. So no cases have reached this point yet, even the ones that were filed early and approved before the official announcement. No one has gotten to this point, and we've heard DHS mention that they might provide more guidance on this. So we're kind of waiting and seeing what cases are eligible for renewals. And next slide, please. Wait, I'm going to turn it over to Kelly now to talk more about the survivor side. Thanks.
Thank you, Lynn. So in addition to the benefits of deferred action for immigrant survivors specifically, which are listed on the slide, one other positive benefit is eligibility for health insurance on the federal health insurance marketplace for immigrants who have deferred action. I'm putting in the chat a link to healthcare.gov, which clarifies that folks with deferred action have eligibility for health insurance. Access to medical care and health insurance, as I'm sure all of you know, is really critical for immigrant survivors who may have abuse-related chronic health problems that they were unable to previously receive treatment for because of gaps in insurance coverage or access to care. And just another point about the importance of employment authorization for this population specifically. These folks have really, they've been disempowered and deprived of agency by abusers, by employers, and often by systems. And employment authorization gives them some sense of control over their life again that they may not have had previously. Next slide, please. So this slide has some examples of immigrant survivors who might be eligible for labor-based deferred action. In the first category, you might have a client with a pending U visa based on domestic violence, for example, and that client might then experience a labor violation at work that is not related at all to the domestic violence that formed the basis of the U visa, but it could be an independent instance of gender-based violence, such as sexual assault or stalking by an employer, which, if covered by a statement of interest, could make them eligible for an EAD quicker. On the other hand, you might have a client who, when they initially present to you, seem like they're ineligible for UT or VAWA-based immigration relief, such as a survivor who is a victim of abuse by a non-qualifying family member and doesn't want to involve the authorities. But that survivor might then experience gender-based violence in the workplace that makes them eligible for labor-based deferred action, and depending on the facts, potentially U or T relief that they were not eligible for before. Next slide, please. Moving to U visa certifications from different labor agencies. Here on your slide are the federal labor agencies that will sign U certifications and T declarations in at least some circumstances. Remember that to be a certifier under the regulations, the agency does have to have the responsibility for detecting a qualifying crime, or if it's a trafficking T visa declaration, responsibility for detecting trafficking. DOL, NLRB, and EEOC's procedures, which are in your materials, assume that the agencies do have this authority to detect qualifying crimes or trafficking. If you're wondering whether a state or local labor agency can be a certifier, you can see if their certification process has language that assumes the authority to detect qualifying crimes, similar to the language in these federal agencies' processes. If the state or local labor agency's process does have that language, you have a good argument that they should be able to certify. You might want to also talk to local practitioners about their experiences with state and local agencies as certifiers, including any pushback that they've received from USCIS. A great way to discuss these issues is to join ASISTA state and local working group. Please email me after the webinar if you're interested in joining, which is run by my colleague, Leah Ocasio, and she's really great. So I encourage you all to join. Next slide, please. Here on your slide, you can see a list of the qualifying crimes that each of the federal labor agencies can certify for. You'll see that there's an asterisk next to forced labor. That's because forced labor is not actually listed as a qualifying crime in the U statute or regulation, but wage and hour division listed as a crime they'll certify for. So I put it on the slide, but just keep in mind it's not actually a qualifying crime, but often involuntary servitude might be implicated in those cases. The crimes that are highlighted in yellow are crimes that OSHA can certify for, that wage and hour division currently does not. And this is helpful to keep in mind because OSHA does have some helpful additional crimes like felonious assault that they can certify for. It's positive that OSHA is now a certifying agency. That's just something that happened this year. But as you can see, they are not currently publicizing that they'll certify for sexual assault in the workplace. And of course, it's absolutely possible that sexual assault can occur alongside a violation that OSHA is investigating. That said, despite what OSHA has said on their website, we have heard that they could certify for sexual assault on a case-by-case basis. So if you have a client who is otherwise eligible for OSHA certification and has experienced sexual assault in the workplace, you might consider approaching them to certify. OSHA has said, though, publicly, of course, that they will certify for trafficking, though. So if you could make an argument that the workplace sexual assault that your client experienced is actually part of trafficking, you might be able to get that OSHA certification as long as the other requirements are met. And Lynn will talk a little bit later about some of the intersections between workplace sexual assault and trafficking. You'll see that the wage and hour division and OSHA, that they only certify for certain qualifying crimes, while EEOC and NLRB are much more open-ended in which crimes they'll certify for. For all of these federal agencies, remember that there does have to be a violation of a law that the agency enforces. And to get an OSHA certification, for example, the qualifying crime must have occurred in the context of a work environment or employment relationship, and there has to be a credible allegation of a law that OSHA enforces. So for example, there has to be both felonious assault in the workplace and some sort of a credible allegation that the employer, for example, retaliated against an immigrant survivor for making a complaint about workplace safety. And similarly, for a certification from WHD, there has to be a qualifying crime in the context of a work environment, and there has to be a credible violation of a law that the WHD enforces. So for example, you have to show that there's both, say, extortion in the workplace and a credible violation that that survivor has not been paid properly. Regarding EEOC, like Lynn said before, and Amy, they enforce Title VII of the Civil Rights Act, and that law forbids discrimination based on certain protected classes. One of those is sex, but it's important to keep in mind for our purposes, sex does include pregnancy and thanks to a recent decision from the Supreme Court, sexual orientation and gender identity as well. So keep that in mind. Next slide, please. This slide addresses, go back one more, please. Thank you. This slide addresses how to prove substantial abuse for U visas based on workplace crimes. This sometimes can be difficult to do, especially if the crime is one like witness tampering or obstruction of justice, which on its face, the argument's harder to make that there's substantial abuse in some cases. That said, remember that one of the factors in the regulations that USCIS looks at to determine if there's substantial abuse is the aggravation of pre-existing conditions. And as an example of this, there was an unpublished AAO decision from 2014, which is in your materials, where the U visa petitioner had a difficult childhood and she was being subjected to sexual harassment and exploitation by her employer. And the employer had told her to lie to the Department of Labor. There was a psychological evaluation in the record that mentioned that the survivor had PTSD because of the employer's coercive practices during that investigation. And really critically, the AAO found it important that this work situation where the survivor was being told to lie to the Department of Labor actually exacerbated what AAO called her already fragile psychological profile. So this decision is important because it shows that if you can demonstrate that the workplace crime, like for example, witness tampering, is actually exacerbating the survivor client's pre-existing mental health conditions that, for example, they might have because of domestic violence that they previously experienced, you might be able to argue that they meet that substantial abuse requirement for the workplace crime that could make them dually eligible for labor-based deferred action and for a U visa. Next slide, please. So for a hypothetical, we have Marisol. She came to your office for an immigration intake. You learned that she works at an e-commerce warehouse and that she is pregnant because of her husband's reproductive coercion. Her husband is not a U.S. citizen or a lawful permanent resident, and she does not want to involve the authorities. She's been forced to carry this pregnancy to term because she does live in a state where abortion care is banned. After learning that she was pregnant, she applied for a shift supervisor position at the warehouse, but management excluded her from consideration because, quote, pregnant people can't stay on the floor long enough. Marisol's manager later told her that he would consider her for shift supervisor, but only if she had sex with him. She refused to do so, but she stayed in the job because she needs the money and she's afraid to look for another job without a work permit. Her manager gropes her every time she walks past him in an empty hallway. Next slide, please. So now we have a poll. If you are representing Marisol, what would your first step be? Would you close the immigration case because she appears to be ineligible for a domestic violence-based U visa or VAWA self-petition? Or would you keep that immigration case open and refer her to a labor rights attorney or organization? Give folks about 30 seconds to respond. Okay, we can go ahead and close the poll. So we have the vast majority of you said that you would keep the case open and refer her to a labor rights attorney or org. And that makes sense. It makes sense to consider alternative forms of relief for her. So it's always important to be assessing survivors for all potential forms of relief and making appropriate referrals if needed. Another valid alternative approach in a situation like this, instead of referring, could be partnering with an expert mentor on the form of relief of, perhaps getting a statement of interest, as long as you have Marisol's permission to be doing that. Working with expert mentors can help you get the skills that you need if you want to make the labor-based portion that Lynn was talking about, requesting the statement of interest, a regular part of your survivor-based immigration practice. If you decide to incorporate the labor aspect into your practice, we also recommend attending trainings on labor and employment law to help you better issue spot potential violations. As Lynn said, typically these cases do come to immigration attorneys after the statement of interest is already secured. But as you can see from this example, there are some cases when you as the immigration attorney or a representative might have the opportunity to issue spot potential labor violations. I'm popping a link in the chat to some slides with some helpful screening questions about gender-based violence in the workplace. Those questions are at pages 27 to 28 of that slide deck. So I would recommend taking a look at those. Next slide, please. So Marisol, she meets with a labor rights attorney who did help her secure a statement of interest from the EEOC. Marisol did participate in an interview with her local EEOC office and told her interviewer about the groping. So based on this, what would your next step be? Would you offer to file labor deferred action for her? Would you investigate the possibility of a certification from EEOC, or would you do both? Okay, we can go ahead and close the poll. Thank you. So most of you said that you would do both, which makes lots of sense. It does make the most sense to consider eligibility for both forms of relief, since it doesn't seem like, at least based on the facts we have, that Marisol has another form of survivor-based relief available to her, and labor-based deferred action, while helpful and the processing time is much shorter, it is temporary. So that's why it makes sense to investigate both the U visa and the deferred action. That said, it's also best to not just consider the U visa, because of course, labor-based deferred action is a quicker path to a work permit than a U visa. And for Marisol in particular, it seems like her main barrier to being able to leave this exploitative, abusive employment situation is her lack of work authorization. And a grant of labor-based deferred action and work authorization can help remove that barrier and allow her to leave that abusive work situation. Next slide, please. So you've decided to investigate a U visa for Marisol, but is a U visa certification even possible here? You can see the two-pronged requirements for an EEOC certification here on your slide. So do we think that these are both met? So let's tackle them one at a time. The first is there a qualifying crime here? Remember, unlike DOL, EEOC doesn't limit its certification authority to certain qualifying crimes. Based on the facts here, this is a pretty clear-cut case of sexual harassment, but we know that sexual harassment is not a qualifying crime for a U visa. That said, what other facts did Marisol share with EEOC about what her manager did to her in the workplace? And feel free to put your thoughts on that in the chat. So she shared that that there was groping, right? She shared that there wasn't so-called just the the threat that, or the offer of favorable employment opportunities in exchange for sexual favors. She told them that there was actual physical, non-consensual physical contact as well. Since Marisol shared these facts with the EEOC about the groping, we know that they've detected that groping has occurred. So now that we know that those are the facts that she shared with them, the next step, what would be your next step in determining whether those facts that Marisol shared, that she was groped by her manager, what would be your next step in determining whether she's eligible for a U visa based on those facts that she shared? And you could feel free to put your thoughts on that in the chat. While folks are doing that, you'll want to research your state criminal law to see, are there any state crimes that cover groping? There might be a crime called sexual assault that covers it. That's a possibility. Another possibility is that there could be a state crime that has similar elements to a federal crime called abusive sexual contact, which is a U visa qualifying crime. And that's found at 18 United States Code 2244, which I just put in the chat. You can take a look at that yourself, but essentially, it criminalizes non-consensual touching of another person's intimate body parts. And some states do have crimes with similar elements. If Marisol's state has a crime with similar elements to abusive sexual contact, her attorney could argue in terms of U visa eligibility that there was a substantially similar crime to the qualifying crime of abusive sexual contact. While your state crimes elements will not be identical to abusive sexual contact, because some of the elements of that federal crime are jurisdictional, like for example, a requirement that it occurs, in a certain place that makes it a federal crime instead of a state crime. You could argue that those differences shouldn't be important because the only real differences are these jurisdictional elements. The main argument is that the behavior that's punished by both crimes, the state crime and the federal crime, is this non-consensual sexual touching. And for a U visa, if we're talking about substantial similarity, we're talking about comparable elements. And again, substantial similarity, not identical elements. So let's assume that we do have a qualifying crime here of abusive sexual contact. Is that crime covered by statutes that the EEOC enforces, or is it related to the complaint that Marisol made to EEOC? And I'll give folks some time to answer that in the chat. So while folks are doing that, the answer probably is yes. And that's because what did Marisol complain about? She complained about the groping, and that is the very conduct that we're asking EEOC to certify for. Alternatively, groping is under the statutes that EEOC enforces, right? We know that Title VII forbids sex discrimination in the workplace. And federal law says that sexual harassment, including sexual assault in the workplace, is a form of sex discrimination. And since EEOC, enforces a law that forbids sex discrimination, and that includes sexual assault in the workplace, a complaint of being sexually assaulted at work very easily fits into that second prong of EEOC's use certification criteria. The last question is, can EEOC certify for a state crime? They don't explicitly answer that question on their webpage that talks about their criteria for use certifications, but there's a pretty good argument that they likely can. And that comes from language that requires EEOC staff to explain any information sharing that they'll engage in with state or local law enforcement agencies. And if they couldn't certify for state or local crimes, it would be unlikely that they would contemplate this type of information sharing. So that suggests that they can certify, even if the crime is not a federal crime. Next slide, please. And just very briefly, some key takeaways from Marisol's situation. While the basis of her U visa certification would be the qualifying crime of either abusive sexual contact or sexual assault, the manager's statement about pregnant workers, that might have itself been a violation of federal law. And that's because it seems to rely on stereotypes about the physical abilities of people who are pregnant, which might be a form of illegal pregnancy discrimination. That statement alone is, of course, unlikely to qualify Marisol for a U visa certification. But say if she was in a different situation, like she already had a pending U visa and she doesn't need a new 918B, that statement alone could qualify her potentially for a faster work permit if EEOC issues a statement of interest for that particular work site that covers Marisol. Of course, it's impossible to have a full discussion of pregnancy discrimination against immigrant survivors without discussing reproductive coercion. Immigrant survivors, they've always experienced reproductive coercion. They've always experienced intimate partner sexual assault. Those aren't new. What is new is the Supreme Court's decision in Dobbs. With Dobbs, immigrant survivors who become pregnant from intimate partner sexual assault or reproductive coercion are more likely to be forced to carry that pregnancy to term, and those forced pregnancies might subject them to pregnancy discrimination in the workplace. And remember that many of these immigrant survivors, because of their immigration status, because of lack of work authorization, they're subjected to a power imbalance with their employer, and that makes it potentially even more likely that they'll experience pregnancy discrimination. It's really important to be mindful of this, particularly for clients who have pending survivor-based cases and don't need new certifications, but who are pregnant, live in a state where they're unable to access abortion care, and are at risk of pregnancy discrimination in the workplace. For immigrant survivors who recently had children, be sure to also consider potential violations of Family and Medical Leave Act protections and denials of accommodation for certain hourly workers who are nursing. The Affordable Care Act put in place some requirements for employers of workers who are paid, I believe, on an hourly basis who are nursing. So keep that in mind. And also remember that some states and localities have much more protective laws on both family leave and accommodations for parents who are nursing. So be sure to familiarize yourself with those as well, as that may help you to issue spot more potential violations. And I will now turn it back to Lynn. Next slide, please.
Thanks so much, Kelly. I am going to very quickly take you all through a few hypos on potential trafficking situations that you might see in various workplaces, industries, and work kind of situations. So first we have Sochu, and she is a DV survivor from Guatemala. She entered the United States without inspection with her young son. She moves to Georgia and begins working in a taqueria. She's paid in cash, much less than she was promised. She's working much longer hours. And one night, her boss takes her into the restaurant's office and rapes her. He threatens for her with deportation and calling ICE if she speaks out about it. Out of fear of his retaliation, she continues to work at the taqueria and is only able to escape because of COVID closures. Does that rise to trafficking? I don't have polls like Kelly does, but I will just quickly answer that it does, and that her entry on her own and with seeking a different form of relief is not relevant once that force is what caused her to provide her labor. Next, we have Neela. She's a single mother and DV survivor from India, and she meets a man through an online dating service who seems like a dream come true. He wants to marry her. He invites her to come to the US so they can meet in person and get married. She enters with her daughter on a tourist visa, and she meets her alleged fiance. He ends up being a monster, sexually assaulting her and forcing her to do domestic work in his own home and also to do cleaning in some of his rental properties. She's only able to leave when she reaches out to a local Hindu temple. Is that trafficking? Yes, it absolutely is. Again, her entering on another type of visa for other reasons, the fact that it's informal work, none of those take away from the fact that she was forced to work through this force of sexual assault. Lastly, we have Lupita. She enters on an H-2B visa from Mexico to work at a seafood processing facility. Shortly after her arrival, her manager begins sexually assaulting her, actually 2 managers, and they threaten her family back home. They say they have narco connections and that if she reports anything, they'll harm her family. She is fully compensated for her work, and they otherwise follow all of the H-2B requirements. Out of fear of this ongoing fear of retaliation, she renews her H-2B visa seasonally and comes back over a period of years before there's ultimately an investigation of this workplace. Is she T eligible? Is this labor trafficking? And again, yes, it is. The key fact here is that even though she was fully compensated and there's no issue about the labor being unpaid, it is still given through force of the sexual assault. All of these are former clients of mine, and I share these in particular to show that the differences in manner of entry, in type of industry, and in the kind of differing circumstances, including being paid for your work, not paid for your work, informal work. There's just so many scenarios that may not fit our typical stereotypes of what trafficking means, but can still make a worker T eligible, and which is obviously a really critical and long-term benefit that has these also shorter processing times than the U visa. Last slide before going to Q&A. And it looks like we'll still have 10 minutes or so for questions. So these are just some practice pointers to think about going forward, recognizing the heightened vulnerability of survivors to labor violations and their precarious status. And I think that's just the key takeaway from this whole presentation, is that even though a lot of times with labor rights and immigrant rights and survivor work, we're thinking about them as different populations, but it's really all the same people facing a lot of the same discrimination and possibly being more vulnerable to it because of their past experiences, survivors. Thoroughly screening for labor violations and immigration intakes. Yeah, this is a big change. I know that a lot in the past, there was probably some labor trafficking and potential U questions in screenings that went to labor violations. But a lot of if they didn't rise to that, I know a lot of immigration practitioners would just refer that person maybe to someone who could file a wage and hour complaint, things like that. Now it has this bigger potential for an immigration benefit that we all need to be thinking about. Partner with labor and employment experts in securing the statements of interest. Again, this is just using the expertise of our colleagues and our community to make sure that we're doing the best job we can on both the labor side that will ultimately benefit the client on the immigration side as well. Recognizing the possibility of dual eligibility. I think Amy and Kelly had excellent examples of how these all can intersect and interact, and how ideally it can benefit clients to utilize all these different tools and all these different types of relief to have work authorization as soon as possible and to have a long-term path to status. Be creative in identifying qualifying crimes and potential certifiers. Kelly really spoke to that, and as did Amy. There's local law enforcement, but there's also all these labor agencies at both the state, federal, and local level who are all have potential to be certifiers. And so thinking creatively about what type of crimes and also what types of agencies investigate those crimes and and potentially those labor violations. And then include language about 1367 protections, obviously maintaining that confidentiality for survivors is paramount. I think that's it. I'm going to send it over to Kelly for some final words, and then we're going to answer the remaining questions.
Thank you so much to you both, Lynn and Amy, for such an informative and enlightening presentation. We're really lucky to be able to learn from you and to have your expertise. So thank you. And thank you to all of our attendees for your really great participation. Just very quickly before we move to questions, I wanted to remind you all that OVW Legal Assistance for Victims, or LAV, and STOP, STOP grantees and subgrantees are eligible for free technical assistance from ASISTA for immigration cases that are either based on, related to, or arising from domestic or dating violence, sexual assault, or stalking. And if you're unsure whether your organization has LAV or STOP funding, I recommend either speaking to your supervisor or the person who's in charge of grants at your organization. If you are eligible for OVWTA, we do conduct our technical assistance appointments via video call on the Google Meet platform. You can sign up for an appointment through your account on ASISTA's website, and be sure to select the OVWTA option when you sign up for an appointment. It's really helpful and important to sign up using particularly the OVW option, because often there are more appointments available through OVWTA. So I encourage all of you who are eligible to take advantage of that. And if you have any questions about whether your question or whether your organization is eligible for OVWTA, please feel free to reach out to me. My email address is on the screen. And before we get to Q&A, just wanted to remind folks to please fill out the webinar evaluation. Mary Kate is going to have the evaluation appear on your screen at the end of the webinar. And we will also send it around with the recording as well. We do read your evaluations and we use them to improve our training. So we sincerely appreciate you all taking the time to fill it out. And we will now move to Q&A. Thank you, Lynn, for sharing that email.
No problem. I think there's one question I'd like to go back to that I answered very briefly, but I don't think I fully explained. Someone had asked about the legal standard for these applications and if it's lower than U visas. And I just wanted to really be explicit that yes, it absolutely is. And in fact, we encourage filing really simple applications. The idea of this is to keep the bar kind of low, to allow as many workers as possible to be eligible, and also to get them filed more quickly. There's just no need to do all the work that you all probably do for UTs and VAWAs. We don't need to provide lengthy declarations or mental health evidence. It's really going to be pretty straightforward with the statement of interest, and then potentially some other easy positive equity evidence, such as proof of US citizen family members, maybe proof of participation if they've been interviewed already in the labor dispute by the labor agency. But primarily your positive equity is going to be that statement of interest and that labor agency requesting prosecutorial discretion for workers at that work site. And so, yeah, keep it simple. Less is generally more with these applications, but no substantial harm, no proof of kind of individualized harm from the labor violations that are happening at the work site is required.
We had a question. Someone was asking about, at our initial intake, when potential clients call, our intake paralegal asks if there's been any sexual or domestic violence. What questions would be good to identify a case that would qualify for deferred action based on a labor violation? I can put in the chat again the ASISTA slide deck that for a presentation that we did with some other organizations a few years ago about sexual assault in the workplace that does have some helpful screening questions. But Lynn, was there anything else that you wanted to speak to on that, or Amy?
We have an intake form that we created as part of the practice advisory that I think is linked to the materials for this webinar, but that one is actually specific to screening a client after they've already been covered by a statement of interest, and not to initially screen for eligibility. Amy, do you have some suggestions on this?
I do. I'm just thinking off the top of my head. I guess we're a bit unusual in that we do both employment and immigration law, but if your practice is primarily immigration, maybe just something general to open it up, like, have you ever been mistreated on the job? Can you tell me about that? And then depending on what they say, like, sort of try to consider, has there been wage theft? Has there been discrimination? Has there, what else? I guess like did the assault, if there was sexual assault or harassment, did that take place on the job? Yeah, I guess, and then it's just sort of just something general to, and if the answers are all no, then that doesn't apply. But if there's some yes, then answers of yes, then you can sort of explore further to see if there are any labor rights violations. And I think, did someone mention, I'm sorry, like an advisory with questions? I feel like there are probably more specific questions that could be asked, but just depending on how the person at intake answers. But I think sort of generally, have you been mistreated at work? Tell me how, and sort of going from there.
And I would just add to that I think for immigration practitioners, I think having some really preliminary questions that can just tease out a little of what Amy suggested, and then gather a little bit more information, and then also the date of when these things occurred. I think that will be enough if you think that there's a labor case there, to hopefully get that expert opinion from someone in your community that specifically works with the labor agencies, and kind of go from there. Amy's really fortunate to have both in one place, but I know a lot of folks are working in an organization that does sort of one or the other. But that date is important because of the statute of limitation issues.
We had a question referencing a 1-year statute of limitations and asking, does that start from January 2023 when this new form of relief was created, or from the time of the violation?
Unfortunately, it would be from the time of the violation. There hasn't been, I think there was an ask when OSHA just recently issued its certification process, new process, if there would be any kind of tolling for people who had not come forward for those crimes previously, but they kind of gave a non-answer. And as far as deferred action, it's going to relate to the labor violation itself and to that individual agency's own statutes of limitation, that it won't be tied to the 2023 date, unfortunately.
There's a question about finding CLEs for labor and employment law. Just off the top of my head, there's a labor employment section of your local bar association. They might host some. I guess there could be some hosted potentially by unions or other or nonprofit organizations. Lynn or Amy, do you have anything to speak to on that?
Just that I would look into one. Yeah, I would just kind of search where CREs are generally available. I don't know if there's a lot of like ASISTA type organizations on the labor and employment side, but also just getting to know the kind of the landscape of your local community as far as organizations and worker centers that work directly with workers, and kind of going from there in terms of building that partnership, and also figuring out how to maybe cross train on these issues.
We have one more question. I know the interpreters are almost done, so we will be very brief on this. The question is, if you refer a case to the Department of Labor to investigate, have you had any issues with getting information from the Department of Labor about that investigation when you have also requested a statement of interest? And do investigators invite attorneys to attend interviews with the client? Great question.
So there isn't necessarily a lot of communication about the course of the investigation, but an attorney is always permitted to sit in on an interview. So you can always make that request. They must have language accessibility in terms of interpreters. As Amy mentioned, it's not always the best. And you will, I think there's been at least enough communication to know that the cases have been open or being investigated to a sufficient extent to request the statement of interest. But while the investigation is open, I believe there's limitations on what the labor agency can share in an open case.
Thank you for that. And thank you, Lynn and Amy. And also thank you, Cristina, for your help with answering so many good questions. We all really appreciate it. And we will see you all for our next OVW webinar in July, which will be on policy issues impacting immigrant survivors. Thank you all so much and have a great afternoon.